Hello, Imelda. I'm Susan, and I'm here to talk to you about your boundary dispute with Anakim concerning a proposed fence and also the non-legal issue that is causing a lot of problems between you two, and the option of using mediation as an alternative to litigation. I will briefly explain what a mediator is, its advantages, and its process. A mediator is a facilitator who's there to assess the parties to come to an agreement that is beneficial for both of them. A mediator is also totally impartial, so will not be representing you or Anakin or pass any judgment of their own. Now I'll explain to you the process of mediation and the procedures involved. The first stage of the mediation process is called the opening phase. In the opening phase, there will be a joint meeting with Anakin and yourself present. The mediator will introduce himself and briefly outline the dispute and also set some ground rules, such as the parties each will have full opportunity to bring their case forward. The party must not interrupt the other party while speaking. Rather, they are encouraged to write on a piece of paper if there's any contention or disagreement, and they should be raised when they have been given the opportunity to speak. The parties must not use rude, aggressive, or abusive speech at all times. The entire proceeding is confidential and the meeting is without prejudice. If no settlement is reached, then the parties will not use anything they have learned during mediation about the other party or pass it to a third party. The entire discussion is completely confidential. The mediator will not repeat anything that a party has said unless they have been given express permission to do so. The meeting is completely voluntary, so the parties can leave at any time they wish, and the mediator can also terminate the meeting if it appears that it's not working at all. If no agreement has been reached, then the parties are not bound by what has been discussed. An agreement will only be binding if it has been drawn up and signed by both parties. The next stage is the exploration stage. The parties will be directed to their private room for a personal meeting with the mediator. However, the parties could have a joint meeting instead if they're willing, and they'll present their case. And the mediator will also encourage and help them see and evaluate the position so they can move to the next stage, which is the negotiation stage. In the negotiation stage, the parties must put forward a proposal for a settlement. The mediator will guide them but will not write a settlement for them. So therefore, the parties have full control over what they can have and what they can put in a settlement. Usually, it's most likely that the parties will firstly negotiate on the minor issues such as the car park or the dog or the rubbish bin. So this will ultimately encourage them to later on deal with the major issues. And lastly, the mediation enters into the settlement or the closing phase. The parties should now have reached a settlement. The mediator will confirm the reached agreement, and if lawyers are involved, ask them to draw it up. If not, then the mediator will draft the agreement. The mediator will not leave the mediation until both parties have signed it. However, if no settlement has been reached, then the mediator has to write a detailed account of the reasons why the mediation did not turn into a settlement, and then organize a joint meeting with the parties and confirm whatever the outcome is. So this is the process of mediation. I will now outline some general advantages of mediation for you to consider. Firstly, the parties have full control over the process, and agreement is between the parties. It's not imposed by the court. The mediator is impartial. It's professionally experienced and trained in dealing with such problems and will not take side or pick a winner. Instead, they would focus on moving for the best way forward. The mediation also reopens communication between the parties, as in most disputes, the parties are not aware how the other party feels. Mediation is also cost-effective and speedy. the most disputes will be resolved in one day in comparison to court proceedings, which will take a very long time and is very costly, as well as in the case of Wilkinson. The estate of Brian Wilkinson and Farmer, a cost of $240,000 incurred. And the meetings are private between the two parties, so it's away from the spotlight, and the parties can agree on rights in which the court cannot, because the court will try to find the legal boundary, whereas the parties in mediation will not just consider the correct boundary, but the best boundary for both of them. Now I will specify the particular advantages that will benefit you in this case. So the cost of mediation in comparison to litigation is a clear advantage to you, because it's very hard to determine the boundary line, because it's so rare. That's why it's so expensive, such as in the case of Wilkinson, and also in the case of Huntley and Arms 2010. It was only like 14 inches, and the cost was around £80,000, which is very high. In addition to that, in the case of Thompson and Collins 2009, the parties had to pay about £40,000 just to bring the case to the court. So the cost is extremely high, although I'm not suggesting that for your case it will be the same, but usually it's very costly, so it's better to opt for mediation first. And throughout the mediation process, you maintain control, so you can come up with agreements that suit you, that works for both of you, such as you can determine the boundary line and agreements, and there's no winner or loser in this case. Also, mediation reopens communication, so you can have you can rebuild your relationship with your friend Anakin, because this will because it encourages both of you to openly discuss your issues in a healthy environment. As Anakin used to be good friends, as Anakin had an accident and you were there for him and you helped him with shoppings and stuff, and because of this dispute, you two no longer speak to each other. So this method could really help you rebuild your friendship. And also, there's no harm in trying mediation. Nothing will happen, and everything that you've discussed in mediation will not pass to court. So, and even if nothing works out in mediation for you, then you can still go ahead and proceed to court. So it's best that you use mediation as a first option. Now that we have discussed the mediation advantages, I have written a draft agreement for you, and you have agreed to the following: that you will try to ensure your dog doesn't leave excrement on Anakim Skydriver's garden. If it does, you will clean it. You have also agreed that when your family and friends visit you, that you will ensure that they park their cars as close to your property as possible and not near Anakim's property, or block his driveway or car or anything. And Anakim in the agreement has also agreed to the following: that he will not listen to music at a very loud and unreasonable volume, and he will try to put down the windows so it doesn't disturb you. And he has also agreed that he will put the lid of the bin down whenever he throws out rubbish, so the smell doesn't disturb you, because the smell does bother you. And if these are complied with, then the fence will not be put up. However, if one of these agreements is breached, then Anakim can put the fence back, but on the boundary line that you have both agreed, so halfway between both of your properties, so therefore 15 centimeters from each party's property. However, if Anakim still does not comply with these agreements, then you can enforce it contractually, or you could ask for further mediation. I hope this has helped you. If you really need anything else or want to know more, then feel free to ask. Thank you.